Some torts hypotheticals cover many different theories of liability. This torts hypothetical covers one theory of liability. Let's take a look at the call of the question and see how well we can organize it before we even look at the fact pattern. We are asked, 1. What rights, if any, does Carrie have against owner and against plumber? Discuss. Well, that doesn't tell us very much, but we do know about 2 lawsuits, and for each lawsuit, the plaintiff is going to have one or more theories of liability and one or more prayers for relief. 2. What rights, if any, does Amy's have against plumber? Discuss. The fact that it is Amy's rather than Amy suggests that we're dealing with a business entity as a plaintiff, and we've seen plumber before as a defendant. Question 3. What rights, if any, does Emma have against owner and against plumber? Discuss. Well, we take a step back and consider these 3 calls of the questions, and we see there are many lawsuits in this fact pattern. Carrie versus owner, Carrie versus plumber, Amy's versus plumber, and Emma versus owner, and Emma versus plumber. So we can sketch out all of these lawsuits right up front before we even read the fact pattern, realizing that the plaintiff will need one or more theories of liability and one or more prayers for relief. Of course, we also acknowledge that the defendant is likely to have defenses both to the theory and to remedies. Go to the top of the question, and we meet owner and plumber in the very first sentence. Owner hires plumber, a plumbing contractor, to fix plumbing in a store that owner plans to lease. In performing the repair, plumber used a connector on a hot water pipe made of a different metal than the pipe itself. As a result of the incompatibility of the 2 metals, the connector corroded and weakened. The condition wasn't obvious because the weakened connection was located within a wall. After the repair was completed, the store was leased to Amy's, a swimwear retailer. All right, well, we've already read half the fact pattern, and the only thing that we see that anybody has done wrong is the plumber has used the wrong type of pipe. That would be considered an act of negligence, and we'd compare this plumber with other plumbers in the jurisdiction to determine whether or not this was truly a negligent act. Looks to me like almost certainly it will be. But now let's go to paragraph 2. 2 years after the plumber finished their repairs, the connector burst. Hot water broke through the wall and sprayed into the store, scalding Carrie. Carrie's our first plaintiff. She's a customer who is in the store at the time. The water also ruined swimsuits on display in the store. We pause for a moment to reflect on the irony of swimsuits that are not waterproof. But having lived in various beach resort communities in my life, I suppose it has been my observation that most bathing suits do not get exposed to water a great deal. While repairs were being made, Amy's had to close for 2 months during the summer, causing significant financial loss. Emma, an employee of Amy's, lost her job because of the closure. And then we get the calls of the question again. Now, what's interesting about this question and what makes it well worth our review is all of the plaintiffs in this case have got the same theory of liability. This is not one of those questions that requires us to go through our checklist and come up with all of the various different theories of liability. This is a question that's testing our knowledge of one theory of liability. So how come we've got to do it in 5 lawsuits? Because this allows the examiners to test our understanding of negligence at great length. And you'll see language like this very commonly used both on the multi-state and on the essays. And remember, negligence is the single most important issue on any bar exam because it's worth 14 questions, more or less, out of a 200-question multi-state. This is a topic you need to know well, and you need to be prepared to analyze it, either in an essay format or objectively. So, we consider Carrie versus owner. Carrie is the person who was scalded in the store. She's suing owner for negligence, and we'll consider negligence in a couple of different ways. Obviously, the big way we'd consider negligence would be for vicarious liability. And we look at the plumber. We see that the plumber is really an independent contractor. We look at owner's conduct, and we think about this question. Has owner done anything wrongful? Did the owner do anything careless in hiring the plumber? There are no facts that suggest he did. It's not as if he hired his out-of-work alcoholic brother-in-law to come in informally and try to fix this. The owner hires a contractor. The contractor is independent, does the work outside of the supervision of the owner, and plus, we consider this. The repair is hidden within a wall. How could we expect the owner to inspect the job or to do anything else to prevent the harm? From my point of view, we probably can't. So we look at Carey versus owner, and we find that number one, the owner did not do anything careless himself, and number two, the owner really wasn't in a position to properly supervise the independent contractor. So I think we can make a pretty good case that Carey doesn't have a valid claim against the owner. But Carey's claim against the plumber is virtually certain to succeed. We consider the plumber's negligence, and we see that almost certainly using an incompatible metal would be a breach of the ordinary standard of care that we would expect of a generally competent plumbing contractor. Now, we consider causation, and here there's a little wrinkle that's well worth considering. As we consider proximate cause, what we look to is to see if anything happened between the act of the defendant that the plaintiff calls negligent and the injuries that were suffered. And here, although nothing affirmative happened, we are told that 2 years passed. And so the appropriate thing to talk about in proximate cause is to raise the issue as to whether or not the passage of time would be enough to absolve the defendant for liability from negligence. Now, suppose this fact pattern were a little different. Suppose it took 20 years for this pipe to burst, or 50 years. Well, at some point, the passage of time would be deemed enough to let the plumber off the hook. But to my way of thinking, 2 years really is not long enough to break the chain of causation. So, although it may be true that on the fringes I have a pro-defense bias, in this case, I don't think the plumber's got a valid defense to Carey's claim for negligence. She was scalded, he did a bad job repairing the pipe, a mere 2 years passed, and we expect the plumbing fix to last a whole lot longer than that. So we also look at Carey's conduct. There's nothing here that suggests that Carey in any way contributed to her own injuries, nor did she assume a known risk. It looks as if this pipe was just corroding by itself behind a wall and then suddenly breaks. So Carey is able to prevail against the plumber. She gets compensatory damages for her pain and suffering and for any medical treatment that her burns required. Next, we consider Amy's, the business, versus the plumber. And once again, we focus on negligence. We don't need to do any new analysis here because the analysis that we do for Carey versus plumber is basically the same as Amy's versus plumber. So the theory of liability is not really in play here. We establish it quickly. The issue with regard to Amy's is damages. And what do we know about Amy's? They're a new business. They haven't been in operation for very long, and we see that they are knocked out for a couple of months during the summer. Well, to the extent they can prove up their damages, certainly Amy's will be entitled to recover. But whenever we've got a comparatively new business, damages may be speculative, and new businesses often don't do so well. So will we require the defendant to pay speculative damages? Answer, no. But to the extent that Amy's can prove up damages, and the fact pattern tells us they did in fact sustain significant damages, certainly Plummer will be liable to Amy's for any damages that Amy's can prove up. Now, we turn to Emma. Emma has actions against owner and against plumber. But here we are really being tested about a fairly arcane bit of the law of negligence. We know that pure economic harm is not enough to trigger a valid negligence theory of liability. And what do we know about Emma? Emma worked at Amy's swimwear store. She was not personally injured, nor was any of her property damaged. She did suffer a lost job, so she has in fact suffered an economic harm. But pure economic harm meaning financial damage separate from any personal injury or property damage, Well, it's not compensable in contract. So as we look at Emma versus owner, really, her only possible theory of liability would be negligence. I take it a step further and infer a business tort, negligent interference with contract. But sadly for Emma, she just doesn't have a very firm basis on which to bring her claims either against owner or against plumber. Basically, the injuries suffered by Emma, although to my way of thinking absolutely foreseeable, are deemed legally unforeseeable because she wasn't hurt physically and none of her property was damaged. So that wraps up a consideration of a hypothetical that is only testing one theory of liability, negligence. And as you see here, with 5 lawsuits, all of which are about the same basic theory of liability, the examiners are able to test our knowledge both of how the theory of liability plays out with various parties fulfilling the roles of plaintiff and defendant, but we also see how important a remedies understanding is because Emma's claims for pure economic harm really aren't compensable with the theory of liability that she provides.